What I want to do in this lesson is talk about the termination of a leasehold agreement, of leases specifically. Now, this is going to be a two-lesson encompassed set of videos because we're going to focus on the first few major methods by which you can terminate a lease in this lesson. And then in the next lesson, we'll talk about the final major method, which is, of course, the method of forfeiture, which is a little bit more legally and logistically complicated, and hence why it deserves its own separate lesson. This is actually, in fact, the penultimate lesson on the subject of leases. We're going to spend some time looking at the process of bringing a lease to an end, of terminating a lease. There are a number of ways in which one can terminate a lease. We'll discuss, like I said, the majority of those in this lesson, and then look at a separate issue, the issue of forfeiture, in the last lesson on this subject. So, the termination of leases can be achieved in one of 6 different ways. You have expiry, you have notice, you have surrender, you have merger, you have repudiatory breach, and then finally you have forfeiture. We're going to deal with expiry all the way down to repudiatory breach in this lesson, and then, like I said, one more time for the record, the next lesson is going to cover the issue of forfeiture. For the most part, these are very straightforward, hence why they're not getting their own separate lesson, because they're not that difficult to understand. So we can really just run through all of these really quickly in this lesson, and then the most complicated one we'll deal with in the last. Expiry. This is the most simple formulation for the termination of the lease. A fixed-term lease will provide a start date as well as a duration period in which the lease is active. Once this period has elapsed, that time will expire and the lease will come to an end. There can be a situation where the tenant remains in the property and the landlord agrees to a new agreement, and the point at which the point before that happens, before a new agreement is made, obviously the tenant becomes a tenancy at sufferance, something that we looked at in the previous lesson. But then when they get a new agreement in place, then this turns back into an ordinary leasehold agreement. As I mentioned, multiple different points throughout this series of lessons. Essentially, a landlord or a letting agent doesn't really want to have their tenants just leaving. It would probably be more beneficial for them to have the tenants stay in the property for as long as possible, so long as obviously they're a good tenant and they don't make any noise, or they keep up to date with the rent. So as long as that happens, for the most part, there will be the option for the tenants to agree with the landlord or the letting agent to an extension of a lease, or maybe a new lease agreement, which essentially just allows them to extend the period in which they live there. This is obviously something that takes place in lots of circumstances. In fact, as a little side note, this is something that is going to have to be dealt with by me and my partner this month. So another example of how this all operates. Another method by which a lease can come to an end is through a notice to quit. In some circumstances, the tenant of the property may decide that they want to terminate their leasehold agreement before the expiry date in a fixed term leasehold agreement. If there is a provision within the agreement which allows for the termination of a lease at an earlier time, for the most part and in almost every circumstance this is actually available, owing to the fact that you don't want to necessarily lock your tenants into an agreement of over a year and cause quite a lot of problematic issues when it comes to if they want to quit the tenancy agreement. It may even also be statutory required to allow for the notice to quit. I'm not too sure. However, specifically, if there is a provision in this agreement, it will allow the tenant to release from their obligations with a notice to quit. The third method by which you can terminate a lease is through surrender. This is where there is an agreement between the landlord and the tenant that the tenant is going to give up their rights under the leasehold agreement. This essentially terminates the lease by way of an agreement. They're able to just essentially both come to the conclusion that they want to end the leasehold agreement. So it's a little bit like a notice to quit, but it's a notice to quit that is agreed upon by both parties, by both the owner, the freehold owner, and the leasehold owner, the landlord and the tenant. The idea of repudiatory breach is one in which there is a breach of obligations not on the part of the tenant, which is something that we will deal with when we look at forfeiture, but instead a breach of an obligation on the part of the landlord. In such circumstances, the tenant may be in their right to accept the breach and terminate the lease. This is obviously something that can take place, and one such example of how this is has been established in case law is from a case in 1992 of Hussein and Melchman. In this case, the landlord had an obligation under statute to make repairs to the property that they owned, and this was something, in fact, which they refused to do. The tenants argued that the repudiatory breach was accepted on the basis that this terminated the lease. Their failure to uphold their statutory obligations led to a repudiatory breach, and that the tenants wanted to accept this, which would then lead to a termination of the lease. Fundamentally, the question for the court was whether or not the claimants, the tenants in this case, were entitled to terminate the lease on the basis of this repudiatory breach. As you would probably expect, the court held that this breach was repudiatory, and as such there was the ability for them to terminate the leasehold agreement. This is something that is also affirmed, I'm not going to say reaffirmed because it's an earlier case, but it is affirmed in the case of National Carriers Limited and Panalpina Limited from 1981. This is where there was a leasehold agreement, and essentially it was held that the agreement can be frustrated like any other kind of contractual agreement. For those who want to know more about that, go and have a look at our lessons on contract law for looking at the nature of frustration. Finally, then, we have the idea of merger. Merger is probably the best way of ending a lease agreement if you are a tenant, and this is essentially where the tenant obtains the freehold estate, at which point the lease will merge with that of the freehold, and they will become the full owner of the estate, and there would be no need for a lease to exist. So if me and my partner decide that we wanted to purchase the property that we live in right now, that we rent in right now, then there would be no need for us to actually have a leasehold agreement with the landlord, because we would effectively become the landlords, and we would therefore have merged the freehold and the leasehold estates together, at which point we would just have an ordinary freehold estate. So, like I said, best way for a tenant if they so choose to purchase the property, because then they just become the full owners of that property. Like I said at the start of this lesson, we will go into the concept of forfeiture in the next video, and this covers some of the circumstances in which a tenant may fail to fulfill an obligation, which can then lead to the termination of an agreement and an eviction from the property.